All right, let's get started. Welcome to today's webinar, the Rehabilitation Continuum, working with a vocational consultant within your medical legal case. This webinar is hosted by Medical and Life Care Consulting Services, a case management and nurse consulting firm, and in partnership with CRC Services, LLC, a vocational consulting firm. The content for this webinar is provided solely for informational and educational purposes. This webinar is not a means of endorsement or advertisement for either Medical and Life Care Consulting or CRC Services, LLC, or constitute a formal partnership between each organization. We're excited that you've joined us for this presentation. My name is 𝐸𝐤𝐬𝐿𝐼𝐺, and I'm the moderator for today's webinar. This webinar is anticipated to run about 45 minutes with an additional 10 minutes provided for questions and answers. Participant audio will be on mute throughout the duration of the webinar, and we ask that questions are submitted using the question and answer or chat feature within the Zoom webinar dashboard. Post-webinar, we will share how you can access this content for on-demand playback with a link to a short survey. Again, we're excited to host today's webinar and look forward to an opportunity to work with you. To kick us off, Medical and Life Care Consulting founder and president, Cynthia Bourbeau. Hi, Cynthia, make sure you're not on mute.
Thanks, Gigi, and thank you to our participants for joining us today. Medical and Life Care Consulting Services has provided catastrophic and medical case management services throughout New England and medico-legal services, including life care planning services nationally and internationally for almost 20 years. Throughout our years of case management and life care planning, my path has intertwined with vocational specialists who have assisted either my injured patients or provided vocational expert testimony on cases where I provided life care planning services. Although we provide services to similar clientele, our roles are very different. At MLCC, I receive many phone calls from attorneys with questions about how to best support their cases. There are often questions about the vocational aspect of the client's losses, and we educate about the resources available to them. So for this webinar, we partnered with CRC Services, LLC, to talk about vocational consulting, and today's presenters, Kerry, Skillin, and Erin Bailey, have graciously offered to provide instruction on the different services that they provide in this specialty. Ms. Skillin brings 25 plus years of knowledge in vocational rehabilitation and expert witness work with CRC Services based in Long Meadow, Mass. Ms. Skillin began her career helping individuals who sustained workplace injuries in returning to meaningful, suitable employment. Since early in her career, Ms. Skillin has served as a vocational consultant and expert witness in a multitude of cases across various legal domains, including personal injury, medical malpractice, employment law, family law, legal malpractice, and workers' compensation. Additionally, Ms. Skillin worked for a large hospital and healthcare system as a return-to-work manager and worked closely with legal, human resources, department managers, risk managers, and claims staff to create and implement a successful plan to return injured workers within the organization. Ms. Skillin most enjoys working collaboratively with attorneys to educate and strategize how to best use a vocational expert in a case. She has held leadership positions in state and regional professional organizations within her field and served as an adjunct faculty member at Springfield College. Ms. Bailey has been employed with CRC Services as a senior vocational consultant for nearly 15 years. As a vocational consultant, Ms. Bailey performs a wide range of vocational services and began her career by assisting workers' compensation injured workers return to work in suitable employment. Ms. Bailey also vocationally evaluated disabled veterans and created suitable rehabilitation plans under the Department of Veterans Affairs. Ms. Bailey is requested to conduct vocational assessments by plaintiff and defense counsel and subsequently testify before the fact finder on vocational matters to include employability and wage earning capacity, in addition to vocational rehabilitation mitigation in personal injury, medical malpractice, family law, employment law, and workers' compensation. Ms. Bailey conducts vocational and transition assessments of students on individual education plans and at-risk youth to determine their academic and vocational needs in preparation for entering the workforce. Ms. Bailey is actively involved with the International Association of Rehabilitation Professionals on the national and local level. She also served as an adjunct faculty member at Springfield College.
Great, thank you so much to Cindy and Gigi for your introductions, and thank you very much to MLCC for hosting this webinar. We wanted to start and thank all of you again for participating and give you some background information about CRC Services and the vocational history. Our company was established in 1981, and we are a full-service vocational firm. So there are some companies out there that handle vocational services, medical, case management, IME, etc. And all we do at our firm is vocational services related to return to work and vocational consulting and expert witness work. And we have several consultants that are employed within our office and throughout the country. When vetting a vocational expert, if you folks haven't worked with one before, it's helpful to have someone that is either an active practitioner or has been an active practitioner in the recent past, with a specific background in job placement, return to work planning, whether it's in workers' compensation cases, veterans cases, or working with injured workers and understanding not only the medical aspects, but psychosocial aspects, work history, transferable skills, and how that comes into play with returning individuals back to the workplace. It's also helpful to have and align with vocational consultants that have experience and backgrounds in job analyses. That's a term of art that many of you may not be familiar with, depending on how closely you've worked with vocational experts before. And they're not needed in every case, but actually bringing a job analysis in on a particular litigation case can be helpful. We've seen it in our work in employment law cases. For example, I had evaluated a gentleman who had multiple sclerosis and was working on a very large machine in a factory. And he was terminated from his employment and filed an ADA claim indicating that he was discriminated against because of his disability. And the employer was claiming that it caused an undue hardship to accommodate him with what was needed. So in that particular case, he had worked third shift as a machine operator. And so we went in and were there for several hours on the shift that he worked. We observed other individuals that performed the similar duties that he did, took pictures of the machine, and observed all the physical demands of the job, how much standing, walking, bending. This particular machine required someone to ascend several stairs, walk on a fairly narrow walkway and catwalk, and actually lie down in between printing press rollers to clean them, all doing so quickly and efficiently. This was a large toy manufacturer, and like many factories, once you hit the stop button, all systems are off and the company starts losing money. So it's all about working quickly, efficiently, and safely. And as a result of interviewing other members of that team that worked on the machine and supervisors and taking pictures, we were able to present to the individual's physician and then ultimately the judge and jury in the case what those essential job duties were. And jury ultimately found that the individual could not perform the essential job duties, and it became an undue hardship for that employer to attempt to accommodate them. So again, this is kind of a unique situation, not in every case, but there are some cases, and this is where a vocational expert is the person that's best, has the best background that you can use in a case like that. Having a vocational expert that has the counseling background. Most vocational experts have been employed as a rehabilitation counselor, either in a state, federal, or private sector. where they've worked directly with clients throughout their career in helping them returning to work and perform similar duties akin to a career counselor, helping identify suitable jobs. Most vocational experts, whether working with injured workers, veterans, or other populations, school to work transition, and even career changers. So even people that do not have an injury background, but maybe relocating to the area, or they've been laid off, we're looking for labor market trends, etc. So this type of background that your vocational counselor or consultant provides is what allows that individual to then serve and evolve into an expert witness. So what we wanted to do next was actually take a brief poll of our audience before we move forward and take a look at who has used vocational experts before. So if everyone can take a minute and respond, that would be great. Okay, great. So it looks like the majority of you folks have worked with a vocational consultant and expert in the past, and hope it was a good experience. And we also have a fair amount of folks that are here to learn from the beginning. So hopefully we can provide some background information for you. Next, let's talk a little bit about what is a vocational expert and what sets us apart from other professions. Based again about background, when you're vetting a vocational expert, we are folks collectively that are knowledgeable about jobs, knowledgeable about the labor market, training, and trends. So what's really important when you're looking to find a vocational expert, and you may look locally and you may find that you want someone regionally or nationally, a vocational expert really can serve in any part of the country or the world. We've had cases nationally and internationally. It's all about understanding how an individual with their impairments, how they can work or not work, and conducting research about labor market in different areas. So the labor market, for example, we're based in Longmeadow, Massachusetts. The labor market here in Western Massachusetts is very different than what it is out in Boston. So we are constantly updating our research about employment trends, what are the training opportunities, what are the hot jobs, if you will, in a particular area. So you want someone that has that knowledge and or knows how to get that knowledge and research to provide in your cases. There are vocational experts that we would consider more generalists. They have perhaps a broad background. Most folks will have the national certification is called a CRC, or a Certified Rehabilitation Counselor. And then there are approximately 225, 250 board certified vocational experts. It's a much more stringent certification to achieve. There's a peer review process that goes through that with an examination and demonstration of several years of testimony experience. As with any profession, if you haven't worked with a vocational expert before, you've probably worked with a medical expert or other experts. And in this world of DABERT, et cetera, as we'll get to in a minute, you want to ensure that your expert's following the same type of methodology. So for example, we handle approximately 60% of our referrals from defense firm and approximately 40% from plaintiff. And we want to ensure, no matter who we are retained by, which side of the bar, that our consultants are following consistent methodology. You never, as an expert or when vetting an expert, want one product for plaintiff cases and one product for defense cases, or change your methodology at all. You want to ensure that you're following consistent methodology and that your methods are reliable, and where we're looking at peer-reviewed articles and treatises within our field. In terms of additional background with job placement, we've talked about developing return to work and retraining programs, and working with individuals with a variety of disabilities when you're seeking a vocational expert. So we may get calls and say, have you ever worked with young adults? Have you ever worked with teenagers? Have you ever worked in birth trauma cases, quadriplegics, paraplegics, etc.? So someone who has a wealth of background, wealth of knowledge, if you will, of working with people with a variety of disabilities in their field. Next, we want to talk about what is the methodology of a vocational expert. When we talk about Daubert or various state motions of admissibility, there are many different methodologies within our field. Tim Field is kind of considered the pioneer and guru of private sector vocational expert witness and consulting services. And there are several others who have come along after him. And within the standard methodology of what we all subscribe to, there are different aspects of what we do when we talk about conducting a case analysis. And we want to ensure that we're following methodologies consistently between those cases. And I can't tell you how many reports of other experts that I've read too, where there isn't a foundation, there is no real methodology that's being followed. It's more relying on an individual's self-report, but without the meat, without really following the methods that are subscribed to and peer-reviewed within our field, which is very important. One of the things when it comes to admissibility and Daubert challenges, for example, the scrutiny within our field is that we are a social science. We're not a hard science. So unlike physicians, we don't have the x-rays, we don't have the diagnostic reports. But although we are a social science, there are very objective parts to our methodology. We use and employ standardized testing, which is very scientific. We conduct what are called transferable skills analyses, which is looking at the type of work an individual has done before or vocational activities. Maybe they were head of a PTO or a coach, volunteer in their church, and look to see with whatever limitations or restrictions they have, the other types of work that they can do. That's part of a transferable skills analysis. And that does compare that residual functional capacity with the Department of Labor definitions and various occupational data sources. So there is a scientific process or processes, if you will, to parts of what we do. And again, just reiterating, following those consistent and reliable methodology from every case that we do to ensure that it can be copied is important in following. If there was ever a Daubert motion filed, is that we can look to and show and demonstrate that we've done the same thing in all cases and relied upon the same types of vocational treatises. So that provides a little bit of a background of the methodology and what a vocational expert is. And I'm going to pass it off to my colleague, Erin Bailey, who is going to discuss a little bit more of the different types of courts where a vocational expert is used and more about the process.
Great. Thank you, Kerry. And thank you to Gigi and Cindy for having us today. So Kerry introduced who we are as a company and what a vocational expert is and the methodology that we use. And I'm going to speak about where you often find vocational experts. And many vocational experts begin their career working on Social Security disability cases. And you can work in a couple different capacities within this realm. And the first one is by serving as an impartial vocational expert in a Social Security disability hearing. And in this role, the vocational expert is classifying the claimant's past work and responding to hypothetical questions posed by the judge. After the expert responds to those questions, they are then cross-examined by the claimant's attorney if they're represented. The other area in which we work in these cases are responding to interrogatories that are posed by the claimant's representative. Oftentimes we're asked to respond to written interrogatories that they can submit into the record on behalf of the claimant based upon the medical records that were provided. The natural evolution following Social Security disability hearings is working on workers' compensation matters. And these cases require more of an analysis of the claimant with regard to their age, their education, their work history, their transferable skills. In these cases, we do conduct an in-person vocational examination that will consist of a structured vocational interview and administration of vocational testing. And we then score the testing, interpret the results, conduct a transferable skills analysis and labor market research, and provide an opinion on the individual's wage earning capacity or lack thereof. In personal injury matters, there's a wide range of cases that we'll work on. Motor vehicle accidents, slip and fall accidents, sexual assault cases, cases where there was slip and falls, not necessarily slip and falls, but the person fell from baker staging on a construction site, for example. And in these cases, depending on the parties involved, we may or may not have access to the plaintiff. And so our opinion is based upon conducting a records review. So here we rely upon a deposition transcript, the medical records, response to interrogatories, a complaint. If there's an opposing vocational expert, we'll read their report and obtain information if necessary from that source as well. And we're engaging in the same methodology as previously described, conducting a transferable skills analysis, labor market research, and rendering an opinion on employability. Medical malpractice, wrongful death cases are also areas in which we are retained on. Depending on the type of case, we may have to make some assumptions. So on the wrongful death matters, if it's a younger individual, we may have to look at records from families, and we'll talk about that in a little bit in terms of how we handle kind of the younger population. Employment law cases, so if someone is terminated, they can claim a discrimination, for example. We've worked on cases where there was a female or a woman who was pregnant and she was not allowed to come back after her maternity leave. So it could be discrimination from having children or being disabled or so on. In divorce cases, we're retained on to determine or help the parties determine attribution of income. So we're looking at the wage earning capacity of a spouse, could be the referring party, and or the spouse to determine what they could earn following their divorce. In other cases where experts are retained on are long-term disability, veterans law, and education cases. Veterans law, the consultant is evaluating a disabled veteran to assist with the veteran obtaining total disability under individual unemployability benefits through the Department of Veterans Affairs. And in education cases, we are retained to conduct transition assessments on students that are receiving an individual education plan and help with providing recommendations based upon what they may need to transition from school to work or independent living, or what they may need in a fifth year. In personal injury cases, to kind of comment on this more specifically, so as I indicated, these are our product liability, medical malpractice, sexual assault. We're looking at the individual's pre-injury vocational background. So we want to really understand what they were doing for work, what their job required from a physical standpoint, also cognitively, if there's any cognitive issues that are going on that we need to consider. To determine the pre-injury wages, we're reviewing tax returns, which is an objective way to measure what the individual was earning. Typically, we prefer to review tax returns 3 years prior to the injury. This gives us a representative sample of what the individual was earning, and we can determine if there are any jobs in which a person can perform that are close to their pre-injury wages. As a part of reviewing the records in these cases, we're looking at the mitigation and their job search efforts. So, for example, I had a case where the person was a union carpenter or union construction worker, and he did not have a high school education or a GED, and he fell off baker staging and sustained some pretty serious injuries. However, during his recovery, he didn't do anything to improve his situation. So he did not look into obtaining a high school education or a GED or determine what the best avenue would be to obtain a high school education. There are various ways that one can pursue a high school education nowadays, not just through a typical GED examination, but there's also national external diploma programs, which is more portfolio-based and designed for those that have been out of the academic world for quite some time and have some job search, or excuse me, work history. So he didn't do any of that. So a section of my report really considered what he could have done, or what he can do to improve his situation, therefore increasing his access to jobs. As a part of our analysis, we're looking at, again, what the person did in terms of their job searches. So we will look at their job searches, and if there's any records to review, we will analyze them in depth, and we'll create charts if we need to, and give the fact finder and the parties involved in the case a visual as to what the job searches looked like. So for example, we may make charts of the numbers of jobs and the types of jobs that the person applied to in a month. And we'll go on and do that for several months to show that either the person really did engage in a diligent job search or they did not. And we're providing an opinion ultimately on their employability and their wage earning capacity. And so we're doing this by conducting a post-injury vocational analysis. So we're considering the person's age, their education, their past work experience, their residual functional capacity, and we're determining the labor market and the types of jobs they can perform and what those wages would be. In talking about injuries and wrongful death of young adults and children, these cases are different than working with an adult for many reasons. The first one is that they're just younger, so they may not have any type of vocational background, or they may have not been on any trajectory to perform any specific type of work. So in this case, we want to look at their academic records, if there's any, depending on their age, if they took the SATs, for example, we would want to look at the SAT scores. If they're on IEPs, we would like to look at those to determine what their strengths and opportunities for growth is. And when working with the younger population, if there is no vocational pattern established or no specific vocational interest established, we're going to look at records and try to obtain information from anyone that was really influential on their life. So to put this in context, I was working on a case a couple years ago where it was a 4-year-old little girl and she drowned in a lake. And so we were retained by the defense, and part of the claim was lost wages, future lost wages. And in this particular case, her parents did not have custody of her. There were some substance abuse issues and just really not a healthy living environment with the parents. And so although I considered their work background, which was of a CNA and I believe a plumber, I really looked at the work history of the grandparents and the aunts and uncles who were really involved in her life and who she had lived with. And so I was considering everyone's vocational and educational background when determining an opinion as to what this little girl could have performed for work. And I'm using that information to analyze the most probable vocational future. So that's with regard to their education, their training, and their work. So in this case, it was clear that it was more vocationally probable than not that she was not going to pursue a 4-year college degree or any type of graduate degree. She may have been a technical training student or pursued a job where she had some on-the-job training. So we're looking at these cases from a different perspective, and we're reviewing deposition transcripts, and we're engaging in the same methodology, but the sources of our information are slightly different because of the lack of vocational history of the individual. So now that you have an understanding of who we are, where we can be found, Kerry's going to discuss the referral process and the steps that we take when beginning to work on these cases.
Thanks, Erin. So in the referral process for cases, we always like to have a preliminary discussion with the attorney. We want to understand what it is that you're trying to prove, what's your strategy on the case. It's helpful for us, obviously we're not attorneys, but just understanding your perspective of where you're coming from We do like to work closely with the attorneys. Part of the way we see ourselves are as educators. So we like to work closely with the attorneys, educate you as to how we may or may not, or how we can help you on the case, where our limits are, other experts that might be helpful, or the type of experts, whether it's a life care planner like Cindy, whether it's an economist, and others, and help you strategize that case. We always want to run a conflict check. This is something that comes up. As I mentioned in the beginning, at least in our firm, we have a pretty close split of plaintiff and defense work. We've worked very hard, and we're very proud of being able to do that. And so we want to ensure, before we delve too far into a case, that we're able to run a conflict check on a particular case name and the various folks that are involved. Most of the time, in terms of the material that we want to receive, is going to be the same in those cases. Erin talked about looking at tax returns, obviously medical records, and the background information, deposition transcripts, etc. And we do still kill a lot of trees, unfortunately. So we do like to have paper copies of all those that we go through. We're often asked to bring all that information at depositions anyway, so we do have that. And sometimes there's more information that we might need. Again, you folks respectfully are looking at the case from the legal perspective of what you can prove or not prove. And obviously we come in the side of the damages. And especially in civil cases, what we find is that physicians aren't always accustomed to providing work restrictions. And so they are, if they are working with someone in workers' compensation, a patient that's receiving workers' compensation, they're used to providing opinions at almost every follow-up visit because they're hammered by the claims adjusters to do that. But if you have a car accident or slip and fall or other type of civil case, the physicians are not always accustomed to doing that, or they provide opinions that someone has a light duty capacity. But what do they really mean by that? The interpretation is different for me of what a light duty capacity means than perhaps what that physician is thinking of. So sometimes in speaking with you folks as the attorney, we might suggest getting some additional information from the physicians or helping fill out checklists. Or if you're deposing the doctor, we can assist with those types of questions as well. Some of the most important information we want to know, or any expert, quite honestly, are disclosure deadlines and trial dates. I'm sure I'm not alone as an expert saying that the sooner we get in, the easier it is. It's not to say that we or other experts can't handle 11th hour cases, but it's certainly not where we want to be. So having an understanding of what those deadlines are is helpful for us for our planning. And then the referral process ends with the retainment. So we, along with most expert witnesses, have a retainer that we send out as our contract, if you will. And then once we are formally retained, then we can start in on the case. So then we can start our case review and have that discussion with you. Before we go on to the next slide, we're going to have one more poll here to see how many of you have worked with a vocational expert and considered using one in a life care plan. So this is a little different. If everyone could respond to that. Erin's going to address this in a couple of slides in talking about catastrophic cases. Okay, helpful to know. Looks like no one yet, at least, that have responded, have not worked with a vocational consultant in this area. Again, Erin will address this in a couple of slides. Now just really kind of talking about the meat of how do we strategize? How do we work these cases? What do we do when we analyze a case? Again, doesn't matter if it's plaintiff or defense, we're going to go through the same process. After we're formally retained, everything starts with a records review. We're going to read all those medical records, deposition transcripts, tax returns, employment files if you have them or can get access to them. So we have a good understanding of job descriptions, performance reviews, especially if there are any attorneys on here online that are employment lawyers. We want to have an understanding of performance reviews, job descriptions, the hierarchy at a particular employer. What does that food chain look like and where does the plaintiff fall? After that records review, we'll have a discussion with you and say, here are my thoughts. Here's kind of the good, bad, and the ugly. This is what we see so far in terms of employability and wage earning capacity. Again, those are the two primary areas that we're going to give opinions on. And what's missing? Are there other records that we need that may be out there that would be helpful? Maybe they exist, maybe they don't. Cases where we talk about next steps. Do you want to use us as a consultant, or do you want to disclose us as your expert? And depending on where you are in the case, there's kind of pros and cons to both of those things. I think in speaking with a lot of attorneys over the years, some feel that, gosh, if I hire an expert, I'm all in. I'm going to have to disclose them. And oftentimes you might not need to. You might not want to. We are retained fairly frequently as an undisclosed consultant. So on either side, a plaintiff attorney may call and say, hey, Kerry, can you take a look at this case? Give it a review and let's talk about what your thoughts are. Again, give me the good, bad, and the ugly. What do I have a case? Do I not have a case? How do we develop it? And on the defense side, it may be, can you take a look at the other vocational experts' report? Take a look at the file, give me your thoughts. Are they on target? Are they off base? Can you help me with deposition questions for the opposing expert? Let's wait till we're a little closer to see if the case will settle or not. I will say that most often, if there is a plaintiff vocational expert and we are contacted and retained by the defense, and if we can provide an opinion that is favorable to the defense, then most often we are disclosed. That's when you would want to disclose experts, so that you have kind of a battle of the experts, if you will, so that there isn't just one side. But again, consideration of a consultant, especially early on in the case. We get cases sent to us. I'm working on one now that's not even in suit yet, and working alongside the attorney to develop this side of the damages part of the case. The other aspect to consider are what we would call a preliminary report or a more comprehensive analysis. So again, working closely with these attorneys and strategizing, what we've seen in the last few years, and I think now especially in the midst of this pandemic with courts being closed and virtual depots taking place, et cetera, we're in a pretty settlement happy world right now. So people are wanting to settle cases and mediate them because we don't know when the courts are going to reopen and so on. So attorneys are looking more for, sure, I want to disclose you as an expert, but I want something brief, a report, or talking points, if you will, that I can bring to a mediation or a settlement discussion and highlight where our opinion is coming from. So that's a product, if you will, that we can provide that gives you our opinion in a format that you can present and make the arguments in terms of the vocational piece of it. And if the case doesn't settle and it does end up going to trial, then we can look at our more comprehensive analysis. You know, these reports could be 20, 25, 30 pages long, summarizing medical records and deposition transcripts, in-person evaluations when we conduct them, we can talk about in a minute, testing, et cetera, in a lot more detail. And that's the meat that you want to put before a judge and a jury or the fact finder as well. In terms of our opinions, again, whether it's a preliminary report or a comprehensive report, the areas that we're going to give opinions and testify on are employability, placeability, and wage earning capacity. And the term employability and placeability are our terms of art, if you will. And there is a distinction between the two, and I'll explain that. So employability in our world is based on somebody's age, education, work history, their transferable skills, as we talked about earlier, testing results, if we met with the person and did testing, or if there was, for example, neuropsych testing that was fairly recent, we would incorporate those. Our labor market analysis, the types of jobs we feel the person can perform and the wages, or if they can't perform any work at all. And what we term the residual functional capacity, or their RFC, which in essence are, what are their limitations? What are their physical and or cognitive and or mental limitations? So that's someone's employability. That's our mantra that we testify to, if you will. Age, education, work history, transferable skills, testing, labor market analysis, residual functional capacity. The placeability is the end of that coin, if you will, or the other side of the coin, which is what's the likelihood they're going to be hired? You may have, for those that have worked with a vocational expert in the past, you may see language in a report that talks about they're not a competitive applicant. Well, what does that mean if they're not a competitive applicant, or are they a competitive applicant? That's really going to the placeability factor, and that's the area of what's the likelihood they'll be hired. And one of the things that we want to look at as a vocational consultant in any of these types of cases, the likelihood they're going to be hired, well, what's that applicant pool? If we're looking at someone who's been an entry-level blue-collar worker, maybe they've been a construction laborer, warehouse worker, and they don't have a high school education and they've been out of work for 3 or 4 years, what's that placeability factor? Well, let's look at the applicant pool. The applicant pool for, say, a more sedentary or sit-down job or lighter job, light duty, as you may hear, who are the other folks applying for these positions? More likely than not, other individuals who may or may not have a high school education, may or may not have English as a second language, may have no work history at all. So we have to put it in perspective in these cases of what's that likelihood they'll be hired considering those factors. So that's something we want to look at when we're conducting these case analyses. And then there's whether we do a records review and give an opinion, or we conduct an in-person examination. So this kind of goes back to whether we're used as a consultant, or you want a preliminary report versus going in for everything. So a record review gives you a preliminary report, and you can disclose us or not disclose us, but we can give opinions that way. In civil cases, when we are retained by the defense, because we are not a physician, the plaintiff does not have to submit, if you will, their client to a vocational examination. So in those cases, we're forced to only have a records review and give an opinion. If we have the opportunity and the case, it does not look like it's going to settle when we are retained by the plaintiff, we always like to see the person and conduct an in-person examination. And even if you don't know yet if the case will settle, at least that gives us more information than what comes out in a deposition. We can ask all the questions we would in our 2-3 hour interview, perform our own testing on a case. That's helpful. And again, more information in these cases is often better. And on the defense side, if we make the request to see the individual, especially if there is a disclosed plaintiff vocational expert, if that plaintiff attorney says no, well, they can never use that in a deposition or trial against us, if you will, that we didn't at least make the attempt to see that individual. So again, it all goes back to strategy of the case, timing of the case, who the parties are, if you have other experts or not, the likelihood of settlement, etc. All things to consider. Next, I'm going to pass it back to Erin, who's going to continue on some of the other finer points of what we do when we analyze these cases.
Great, thank you, Kerry. So when we do have access to the plaintiff, and as I had indicated earlier and Kerry had mentioned, we conduct a vocational interview and administer standardized testing. And after the testing is administered, we score and analyze the results. So for example, oftentimes we administer tests of intelligence and memory and concentration. And we look at the individual's intelligence to determine their capabilities, or if there's any specific areas in which are not a significant strength of theirs. And we're administering tests of memory and concentration to determine the pain, or the impact of the individual's pain and or side effects of medication on their ability to attend, concentrate, and recall. And so depending on how the individual scores on these instruments, we're analyzing their testing and determining if there's a significant deficit, or if there's the person is functioning lower than they should be given their pain, or if their scores are average despite their significant pain. And we're utilizing these test results in the remainder of our analysis, especially when we conduct a transferable skills analysis. So if somebody has their scores are average, then we are able to consider a skilled work background if they had a skilled work background. And once our transferable skills analysis is completed, we conduct labor market research and analyze the labor market based upon the individual's geographical area. In some cases, this may require research into retraining facilities and getting an understanding of specific training programs, the cost, the duration, and so on. And other times it may take more research into specific licensure with regard to the trades, for example. So what does one need to do to obtain an E1 electrical license if they have an E2 license, for example? We're considering the option of vocational rehabilitation, and in some cases, the individual may benefit from private vocational rehabilitation by way of assistance with retraining, identifying suitable retraining programs, working with the disability coordinator on campus, and so on. And also, once the retraining is complete, then receiving assistance with job placement and job search techniques. As indicated earlier, we'll analyze the mitigation and job search efforts, and then we'll prepare to report a detailed report if requested with attachments as the case requires. And then if needed, we'll testify at a deposition or trial. So in catastrophic cases, vocational experts are used a little bit differently. These cases are typically involving the younger population. Oftentimes you can think of for example, a spinal cord injury. Somebody may have gotten into a severe car accident and received significant injuries, and now they could be a paraplegic. And so vocational consultants are called in to provide an opinion and recommendations based upon public and private vocational rehabilitation services. And these services may include a job coach, retraining, somebody that may need to assist with the retraining and note-taking and determining appropriate academic supports. And vocational consultants are called in to provide an opinion on life care plans to help add to the settlement value of the case. And so we're used a little bit differently, but we're looking at the case from a vocational standpoint and what that individual may need in the future based upon their limitations, and still engaging in the same methodology that we had described earlier. So with that, I believe that it's time for questions.
Kerry and Erin, thank you so much for presenting such a wealth of information and knowledge. I'm sure our attendees are pleased. But before we kick off our question and answer segment, we do want to take a moment to share how you may get in touch with either Kerry or Erin. On the slide before you, you can see their contact information for CRC Services, LLC, and the direct contact information for our presenters. If perhaps we don't get through all of your questions, please feel free to connect directly with either of them. If your question pertains to a life care plan or medical legal consulting, please feel free to reach out to Medical and Life Care Consulting. Okay, let's get started with questions. So we'll give you a minute to load up the queue. You can also feel free to use the chat functionality if necessary. Let's start with the first one. If we retain an economist to opine on damages, why do we need a vocational expert?
All right, I'll take this one. We get this question a lot. My answer is basically, why not? You really need someone to provide a foundation for that economist's opinion. Oftentimes I see, if we're retained by defense, and I'll ask the attorney on that initial call, has plaintiff disclosed an expert? And the attorney may say to me, oh, they've disclosed an economist so-and-so. And I said, okay, well, what about a vocational expert? Have they disclosed a voc expert? They'll say, no, they're just relying on the economist to give an opinion. So I say, okay. And the same on the plaintiff side. We talk a lot about attorneys that an economist is helpful because we have our limits. We stay within our wheelhouse. As I mentioned in the beginning, at least with our firm, is everything we do is vocationally based. So if attorneys call us for life care planning, I say, let's call Cindy or someone similar. Let's use the nurses to give those opinions and talk about the medical aspects of future care. And the same thing with economists. And when we're looking at what's the big number that the plaintiff attorneys are looking at for damages, call the economist after you get the voc opinion. And I've seen many, many cases over the years at trial that plaintiff attorneys don't win that piece of it because they don't have someone that has laid the foundation vocationally that plaintiff is unable to work at all. And so consider that for you plaintiff attorneys of using a vocational expert, because that vocational expert is the one who's going to pull all the pieces together. Even if the doctor has said they have no work capacity, that doctor respectfully isn't a vocational expert. So you need someone who's going to pull all the information together, all those salient points that we talked about: age, education, work history, transferable skills, testing, labor market, etc., to provide that foundation. And then the economists can crunch the numbers and their work based on their work life expectancy. And same thing on the defense side for you defense attorneys, is having a vocational expert lay the foundation of an individual's work capacity and earning capacity, and then let the economists price out any difference over the lifetime with their process and their methodology that they employ. So I hope that helps answer the question. Is really, it's a 1-2 punch. You have the vocational expert and then you have the economist, and that's how it's been successful at trial as well, is having the vocational expert and economist testify one after the other as well. Provide the foundation of opinion, and then the economist to give everybody the numbers.
Thank you. Here's another question. What is the difference between an FCE and a vocational examination?
I'll take this one. So it's a good question, and that's another question that we get quite a bit. A functional capacity evaluation is often conducted by a physical therapist or an occupational therapist, and this is a measure of one's ability to engage in any type of exertional level of work. So, for example, the OT or PT is having the individual lift weights, walk on a treadmill. They're also hooked up to a heart monitor to determine any physiological response to either pain or the exertion in which they're putting forth. So it's different in the sense that it's a physical examination, and a vocational examination is not physical. We're really meeting with the individual and conducting an interview and testing, and it's all pencil and paper variety. So it's not a physical examination. It's more of an examination of their background and their work ability, and also their cognitive capacity and intellectual capacity.
Thanks, Erin. To circle back with Kerry, there was a comment here, and I think they just want some confirmation. So regarding the economist, this attendee says, so are you saying the economist really has limited knowledge in kind of the vast supply of medical and vocational facts in the case, and in order to establish that true post-wage earning capacity?
Yeah, so good question to circle back with. So yes, we are saying that. So it's not that they have limited knowledge. They certainly have a wealth of knowledge in terms of the financial aspect, but economists rely on these work-life expectancy tables, and they're not case specific. So without naming names, and for those of you that do a lot of this work and retain economists, you'll see that these work-life expectancy tables are generalities. They're based on age groups. They're based on individuals with a certain educational background, and the economist will attribute whether the person has a mild, moderate, or severe disability. So it's generally speaking, it's not case specific to John Jones, who's 52, has a low back condition, post-fusion, and but has a college degree and lives out in Boston. So the vocational expert is the one, again, who's going to lay the foundation and pull all the pieces together. That's very specific and unique to this individual case. And, you know, any economists on the line, respectfully, they don't have that knowledge and ability of understanding the impact of physical, mental, and or cognitive impairments on someone's ability to work and earn money. And so that's the real differentiation between the two fields.
Thank you. So another question, and Kerry, why don't you pick this one up as well? How do you handle evaluating cases where the plaintiff is non-English speaking?
Yeah, good question. So we have various test batteries, if you will, that were designed to be administered to individuals who do not speak English or who have limited English capacity. There are nonverbal subtests of instruments that we use, and specifically completely nonverbal tests in its entirety: intelligence testing, memory, concentration, achievement, so reading, spelling, math. We use functional tests. Can an individual fill out a job application? Can they count money? And we always like to use an independent interpreter at our in-person evaluations, not a family member, certainly not their attorney or paralegal, but rely on an independent interpreter who is there that will interpret verbatim the questions back and forth, and also with the testing piece as well.
Thanks. So this seems to be a follow-up question regarding your assessment process and testing. So would a vocational consultant, or how does a vocational consultant use their testing to allege pain or the like, and that effect on someone's future employability?
I can take this one. So I think in understanding the question, are we using our testing to determine if the claimant has true alleged pain? And the question to that is, we use the testing to determine how the pain could be impacting the individual. And with that being said, pain is subjective, so we can't determine whether anyone has a true alleged pain or not. But what we can determine is if that person does have significant pain, how that pain is impacting their ability to attend, concentrate, and recall on tasks. And so that's what we're measuring with the use of our testing. We're not necessarily suggesting that pain is the reason that their scores may be lower than they should be. We're just interpreting them more matter-of-factly and interpreting them vocationally.
Thank you. All right, we have time for one more question. So if you have a question that you'd like us to answer, please submit it now. And also, one more that I already do have is, how do you handle rush cases? And can you get a case done at the 11th hour under this changing economy and COVID?
Again, I think it's our wish, desire, role to educate attorneys, send us these cases early. But we know that's not always how it's going to work. So, you know, the benefit of working with a vocational firm as opposed to an individual is that, you know, we're able to shift workloads around as needed so that we can meet your needs. And with that, we have been able to use technology, probably like most of you. Erin and I have continued seeing and evaluating clients. We have done Zoom or Google Meets for interviews. We have continued to see clients following all safety precautions in person to do vocational testing with masks, gloves, social distancing, etc., with parties agreeing to that. So again, it's a conversation that we have, and we look to see what the deadlines are and how we can make it work for you. And fortunately, we live in a world where there's lots of technology available to us. If we were in the midst of a pandemic 20 years ago, it would be very different. But much like you folks, cases are continuing. I had my first virtual deposition a couple of weeks ago, and it was fantastic. So we're really looking forward to using everything that we have now, and if we're in this situation again. So we can certainly make it work, and it's more of a conversation we can have on a particular case and the circumstances.
I just want to add to that, Kerry, that so for the attorneys that are still on, we can only work as fast as you do. So if you need an opinion or you want us to review the records and reports or an opinion's due within a week or a couple days time, we need those records really fast. So we can certainly handle it, but we need the requisite information in order for us to do that. So it seems obvious, but sometimes we get these rush requests and then it takes several days for the records to actually come in the door. So that's why I kind of bring that up. But I get it's obvious, but it does help to have the records really fast.
Thank you. Thank you. Thank you again to both of our presenters, Kerry Skillin and Erin Bailey, for such a fantastic presentation. I'm already getting comments that says you guys did an excellent job. So if you would like to access this webinar for on-demand playback, you may do so by visiting www.medicalandlifecare.com. The webinar should be up and published in our webinar section in about 48 to 72 hours. If you have additional questions regarding vocational consultant, please feel free to connect directly with Kerry or Erin on the contact information shown. Thank you for your participation today. Have a great day, everyone.